If you've ever filed to register a trademark in the United States, or if you've had to renew an existing registration, then odds are you've heard the term specimen tossed around. What is a trademark specimen, and why is it a critical part of the registration process? We've got you covered. My name is Julia Rutledge. I'm a trademark paralegal in the intellectual property group at Ryan Swanson in Cleveland, and this is Candid Remarks. We'll be talking specifically about the U.S. trademark process for U.S.-based trademark owners. The trademark registration process may differ in other countries, and the rules will sometimes differ for non-U.S. trademark owners who file in the United States. With that said, let's cover a few basics. In the United States, trademark rights ultimately depend on the use of that trademark in commerce. A trademark that is not in use will eventually lose whatever rights it may have acquired, even if that trademark is registered with the U.S. Trademark Office. In fact, unless your application relies on a previously filed foreign trademark application, the Trademark Office will not issue a registration certificate for a trademark until use in commerce has been confirmed. Keep in mind that registration is optional for all trademark owners, and trademark rights can be claimed and even sometimes enforced in court without registration. Registration can be a powerful tool to establish and enforce trademark rights, however, so let's get into the use in commerce requirement and how it can be met. Put simply, use in commerce means that the trademark appears in connection with the goods and/or services that the trademark owner offers to consumers. While it is not important that these goods or services are sold, they may in fact be given away for free, it is important that the trademarks are public-facing and the goods or services are actually provided to others. That means that internal company use won't be enough, nor will mock-ups or, with rare exceptions, pitch decks or coming soon announcements. Solid use in commerce evidence will typically come in the form of a photo of a branded product or a screenshot of a live website with a Contact Us or Buy Now button. These are examples of what the U.S. Trademark Office calls specimens. Let's dive into what makes a good specimen. The first thing to know is that there is a formal distinction between goods and services, which has an impact on the types of specimens the Trademark Office will require. What are goods? They are items that a person can possess, physical objects that you can touch or hold, as well as downloadable software you can store on your own computer or mobile device. Take this Ryan Swanson brand mug. First, it is clearly a good, something I can hold, and as you can see, it has our logo right on it. Now, this came from our cafeteria, so this particular mug is for internal use at the firm. But a mug like this that is given to others could qualify as a specimen. The same would be true if the mug had a tag attached to it featuring our trademark, or if it were given away in a box that featured the trademark. And to give one last example, a point-of-sale display could qualify, and that can include an online display such as a website, provided that the web page includes a Buy Now button or other ways to receive the product. Note that a receipt of sale usually will not suffice. We're really looking for an example of the trademark as seen by the consumer before they acquire the products. What are services? They can be an action performed for another, or they can be the providing of information to another. This includes everything from medical services to the design of medical equipment. Non-downloadable software such as an online blog or streamable podcast counts as a service, as is book publishing. These requirements are more flexible when it comes to services as opposed to goods. In effect, any display of the mark in association with the services may be considered use. This means that a simple screenshot of a website or social media post that features your trademark and identifies your services may count as a specimen. Take the Ryan Swanson website, for example. Our logo appears in the top banner, and our services are listed in the menu. Ergo, use in commerce. Of course, you can also use a photo of yourself actually providing the services as a specimen as well, as long as the trademark can also be seen in the photo. Now we have to emphasize one thing. A specimen is only as good as the actual use in commerce that it captures. What do I mean by that? For goods, it means that you have more than a mock-up or a prototype. The USPTO needs to see goods that are on the shelf and available to customers. The drawing board doesn't cut it. Similarly for services, actual use in commerce means that the services are provided for others as of the date of the specimen. If your goods have been discontinued or your services are on hiatus, then you may have trouble showing actual use in commerce at that time. That doesn't necessarily mean your trademark rights are abandoned, but at the very least, it's a good idea in that situation to talk to a trademark attorney about what that means for your trademark rights and how best to maintain those rights in the meantime. To recap, specimens are the examples of actual active use of your trademarks that the U.S. Trademark Office will require of all U.S.-based trademark applicants, as well as all trademark registrants eventually. What may qualify as a specimen will differ between goods and services, but it is always critical to provide genuine, current, consumer-facing specimens. And as always, when in doubt, contact a trademark attorney. This has been Candid Remarks, a video series produced by Ryan Swanson in Cleveland, PLLC. Candid Remarks is the trademark of Ryan Swanson. This video is intended for educational purposes only, and nothing in this video is intended as legal advice. For more information on the topics discussed in this video or other trademark issues, visit ryanswansonlaw.com.